Australian Human Rights Commissioner Lorraine Finley. Thanks for your time. So you had the decision. It says it's lawful. The Minister says he'll mull that over. What should he be considering?
Well, good afternoon and thanks for having me on the show. As was just mentioned in the clip before, it's important to understand what this decision is and what it is not. This is a decision about the legality of hotel APODs, not their morality. So while the court may have said on a narrow technical point of statutory construction that the government can, under the Migration Act, use hotel APODs to detain asylum seekers and refugees, we would urge the government to consider whether they should be doing this. And of course, just last month, the Australian Human Rights Commission released our inspection report into the use of hotel APODs, and we found that hotels simply aren't suitable to be used for lengthy periods of detention. They have serious impacts on the physical and mental health of those who are detained. And you only need to look at the judgment that's just been released today, where Justice Murphy, while upholding the legal argument in terms of lawfulness, made some very pointed comments about the use of hotels as alternative places of detention, and in particular said that as a matter of ordinary human decency, Mustafa Azamidabar should not have been held in the conditions that he was in a hotel for such a lengthy period of time. That really needs to be the priority here, not whether we lawfully can do something, but whether as a matter of morality we should.
So is that the particular issue here, just the length, that if it's a short-term thing, you'd understand, and it's the length? And if so, what alternative would you suggest?
Well, it isn't just the length, although that's an important consideration. We do recognise that there may be exceptional circumstances where you may need alternative places of detention, but hotels simply aren't suitable. And again, when we look at the report that we released just last month, it contained 24 recommendations, not only about the use of hotel APODs in terms of the conditions within the hotels, but also about what happens when detainees are released and post-release support. So this is a much broader issue that really needs to be considered. And the judgment today, again, really highlights that difference between what we can do under law and what we should be doing as a matter of good public policy and basic humanity.
Is it, I mean, to what extent, though, are we talking about facilities available, needing to be built?
Well, Australia has a range of facilities already in relation to immigration detention. In relation to hotels, we certainly do recognise there's been a welcome trend in terms of both the number of people being held in hotels reducing in recent times and the length of time that they're being held being reduced. But again, if I can return to the inspection report we released last month, of the 24 recommendations we made to ensure basic human rights standards are met, only 2 of those have actually been accepted by the department, 5 are rejected, and 17 have been noted. So there is a broad range of work that needs to be done in this area to make sure that we're meeting basic human rights standards.
All right, Lorraine Finley, thanks for your time today.
Thanks so much.